Trade union arrives at the employer's workplace claiming that they have the right to access the workplace. Do they really? This is stuff employers should know.
Welcome to Stuff Employers Should Know, proudly brought to you by LabourNet, management's ultimate HR solution.
And welcome to Stuff Employers Should Know. I'm Barry Gordon-Davis, and over there is Yes Like It Ismail, who's still fasting and definitely not fast asleep, keeping his finger on the button that ensures that I sound okay to everybody. Today we are joined by Jakobus Le Roux, litigation manager for LabourNet in Pretoria, and we're going to be discussing, I'd really say is quite a hot topic. It's one that gets asked of us quite often, and it happens where registered trade unions are exercising their rights at employers' workplaces, generally where there is a scenario of them arriving at the workplace and wanting to start engaging with an employer. But we see that more often than not, employers are from the get-go already have this perceived almost animosity towards them, them-us situation formed straight away, when they're forgetting that it's organized labor. It's somebody that's acting on a mandate from their employees, and they should then start engaging them. But what are the rights? Because there's often a lot of misconceptions about when the union arrives and starts demanding access or demanding information and the like. But we can see that the Labour Relations Act specifically is promoting organized labor.
Yes, sure, Barry. So good afternoon to you and your listeners. So Section 4, it's clearly in the Labour Relations Act, every employee has the right to freedom of association. The employer has the right to participate in forming a trade union or federation of trade unions and to join a trade union. And those rights are entrenched in the Labour Relations Act. So that's very important to start off there.
Yeah, so those are rights of employees, specifically, as you were saying. And then the recognition by the Labour Relations Act of trade unions, and specifically registered trade unions. So when it speaks about registered trade unions, what's a registered trade union?
Well, a registered trade union is a union registered with the Department of Labour. They have a constitution, and obviously they act according to this constitution.
Yeah, so it's not just anybody who decides that, as we said, right to join and form a trade union. So it's only the Act prescribes certain rights to those that are registered, recognized by the Department of Labour, as you were saying. Yes. So when it comes to the rights to registered trade unions to exercise the rights in the workplace, specifically what we refer to as organizational rights, what are these organizational rights that trade unions have access to?
Well, these rights are in the Labour Relations Act. Obviously, Section 12 is trade union access to the workplace. You get the Section 13 right. That's the trade union's right to union subscriptions.
That would basically be where the employer deducts the subscriptions on behalf of the employees.
Exactly. Section 14 is the right to elect trade union representatives. That's your shop stewards. That's correct. And then Section 15 is your leave for trade union activities. And Section 16 is access to information. Important to note, Barry, that obviously you get your sufficiently representative trade union as well as your majority trade union, and this will depend on which right you get.
That's all based on the amount of members a trade union has in a particular workplace.
Yeah,
that would determine whether they are, as you said, majority or sufficiently represented.
Exactly.
Majority, I suppose, is the obvious.
50% plus one.
So more than 50, which means that no other union can enjoy more members than yourself.
Yes.
Majority trade union, as well as a sufficiently represented. So what would be a sufficiently represented trade union?
So that would be a trade union with significant interest in the workplace. So, for example, you can have 10 employees and you can have one employee. That's 1% of you, but that's only one employee. But you can have 50,000 employees and 10,000 can belong to a trade union. That's sufficiently representative. Even if it's not like they normally say the rule of thumb, which is 30%, it doesn't mean
it's a subjective test.
It's a subjective test, and that's why our commissioners will apply their mind as well.
So any dispute, and I mean, we're going to get there, any dispute about whether a trade union is sufficiently represented or not can be decided on by the commission, who would then go and take into account totality of circumstances.
Yes, no, that's definitely true.
Now, let's get straight to the main question of the podcast, which is, yes, we've now spoke about these 5 rights that you spoke of. So, I mean, obviously, we've spoke about the right to access to information, access to the workplace. Now, these are quite serious rights. do all trade unions get these, or how are they split amongst the representativeness of the trade unions? Sorry.
Well, if we spoke about sufficiently representative trade unions, so basically what that means is you'll get your Section 12 right, you'll get your Section 13 right. So that's guaranteed for majority trade unions as well as sufficiently represented trade unions.
And then a majority
Gets then
them
will
all.
You get all your extra, all the fun rights, the extra rights.
That's it. So, okay, so we spoke about the rights from all the way from access to access to information. Now, we said that these are proportionally available based on the amount of representation that a trade union experiences in a particular workplace. Now, the main question: do they automatically have access to these rights?
No, you don't have automatic.
So they can't
access
just,
to the rights.
I'm a registered trade union, I've got members, now I have access to your workplace.
No, unfortunately, it doesn't work like that. I mean, you have to, if you want to bargain with the union, yes, you can bargain as an employer, but you can refuse to bargain as well. I mean, then a union can refer it to a CCMA, and then you can obtain those rights. But it's not automatically given to you.
Okay, so let's talk about the process in terms of Section 21. So, as you say, the union has to first of all notify or serve on the employer notice.
Yes.
What does that notice
Well,
contain?
they need to include obviously their certification. That needs to be from the Department of Labour. They need to include their membership list. They need to show what types of rights they actually want to exercise, and then they need to.
And where they want to exercise.
Yes, exactly.
And once that has been served on the employer, okay, so basically saying this is the rights that we want to exercise, this is where we want to exercise those rights. What happens then?
Well, I mean, then it's the onus is then on the employer to either decide whether or not they're going to approach this union and then collectively bargain. If they don't get any joy from the employer in a period of 30 days elapse, then they can refer the matter to the CCMA then for adjudication.
So one of two things can kind of happen is that the employer refuses to meet with the trade union,
Yes.
or let's say meets with the trade union, but then let's say doesn't
don't get
agree.
joy, yeah.
They don't agree with what the requests are from the trade union. So let's say then obviously the matter then goes into a deadlock. There's a dispute.
Yes.
Then the trade union refers a dispute to the CCMA or bargaining council, depending on where their jurisdiction is, and then?
Well, then the commission will conciliate the matter, which means they'll again try and resolve this matter and see if they can't find an agreement between the parties. If not, then they will issue a certificate with the advisory award. Then the union
and now
has
the
two
union
options.
has an option now. Now this is
There's
when
two.
There's
There's
two
two
options. So instead of like with most disputes where the union would then refer it to arbitration, what's the other option?
Well, they can go on strike as well.
And what interesting to note is that that's one of the rights disputes that employees
one of
are
those
entitled to
exclusions.
actually go on strike about.
Yes.
But they have to choose one of two. They can't
Yes.
choose one, not get in their way, and then go in the other route. So let's say, for example, they don't embark on a protected strike. Okay, and just to ensure that when it doesn't mean obviously down tools right there and then, they have to follow the same provisions, give the appropriate 48 hours notice and the like, or depending on who the employer is, how much notice. But let's say, for example, they opt for that arbitration route. So what conditions or considerations does a commissioner take into account in deciding whether they're going to grant the organisational rights to the trade union or not?
Yeah, so there's a few factors, Barry. So first they will look at the membership count. They will look at the history of the union in the workplace. They will also look at what harm it can cause to the employer. They don't want to encourage proliferation in the workplace as well.
So what that basically means is that they don't want they want to actually encourage a majority trade unions rather than numerous minorities that are going to then cause that proliferation. Creates an administrative hardship for employers.
Yeah, for now, I mean that's what the act says for now.
So then they will decide to then grant it or not. Okay, so where we went through this process, the Section 21 process, can a minority, and I say that not a sufficiently represented, but or a majority represented trade union, but let's say a trade union that really represents a minority of the workplace, can they go through the same process?
They can also refer to the CCMA. They also have those rights. It doesn't mean if you're a minority trade union, you don't have any rights. but they're going to struggle.
Yes.
They're going to have a difficult time. 'Cause like we said, the Act at this stage and case law promotes the majority union approach.
And I think what the employers should consider with that is again, there's that significant interest, because it might be significant role players within the organization. They might not form the percentage, but we have to ask yourself, again, if they embark on a protected strike, how long can they go with, or how long can the employer go without their labor? How long can they go without obviously pay in that scenario? So it really depends on what they do and what interest they have in that workplace. Because even if it's a minority, they might affect the production or the operations of that business significantly, that it might get the employer's attention if them as an organized bargaining unit then start doing things. You spoke about one of the organizational rights, particularly being the access to information. That's section 16. Now, access to information is obviously quite a serious thing. It entitles them to employers' information that the employer wouldn't give up to any other parties. But what don't they have access to?
Well, I mean, there's a lot of information that's privileged. So there's for instance, if there's no permission from employees to give their personal details, that would be an example, privileged information.
And again, with most of these things, what happens? Employer will go and say, sorry, that's legally privileged.
Most of the time, the employer, everything to them is privileged. So that's not the case. I mean, you will need this information, obviously, to be relevant. They can't say they want information that's totally not relevant to the certain meeting, dispute, or let's say, for instance, it's a retrenchment process.
Yes.
If it's not relevant to the retrenchment process, then the information is not relevant.
And that classic age-old request, it's always, I want the financials.
Financials.
So let's say, for example, there is a dispute about the access of information, or the employer refuses to give that information.
Yes.
What does a trade union then do?
Well, again, they can refer to the CCMA, and a commissioner will then look at what harm will be caused to either the employer if the information is disclosed, or to the union if this information is then withheld. And they will then do a balancing test, and they will make a award on that.
100%. So the balance of harm test, effectively. They want to make sure that one party is not more prejudiced than the other with regards to that. And finishing off, really, understanding that these are rights that they have. So nothing can stop a trade union from exercising these rights. Just like an employer has the right to run its business in a way that it sees fit, these rights that are bestowed on organized labor give them these rights. So employers generally should not go and try and, add barriers at every level to try and stop organized labor, because it's the will of their people, right?
Yeah.
What is the approach they should take?
It's going to cause your business much more harm at the end of the day. But obviously, there's certain rules that they need to follow. We've got our act, they've got their rights, they've got their process to follow, but we need to approach this with caution. So if you're going to refuse to bargain, let's say with a union that's got 50% plus, you're going to have disharmony in the workplace. There's going to be unproductive employees. You're going to have the union there each and every day. You're going to have CCMA matters. So I would encourage to at least listen them out if they have the right paperwork, and give them an opportunity. If you start off that relationship from the get-go and you encourage that relationship, it's going to benefit you at the end of the day.
And it's something that's going to be in another episode, but employers need to understand the power of a collective agreement.
Yeah.
And the power of collective agreements, and the enforceability of collective agreements when entered into with trade unions and the like. So really, I think that the underlying message is that employers should rather put more effort into embracing and keeping the trade unions, which is effectively the will of their employees. It's their it's the mandated combined voice of their employees, and manage that within the rules, understanding their rights, rather than just trying to make it a them and us situation. Because it's not, as you say, the trade union, they shouldn't see it as something separate to their employees. They should see it as a mandated version of their employees that they should use to communicate with their employees. However, We've been seeing a lot of situations, a lot in the media, where political parties are getting involved with employers and going and knocking on employers' doors, almost wanting to exercise rights in the same manner as what trade unions who actually bear those rights are doing. What do employers do when political parties or non-registered trade unions arrive at their door?
It's a straightforward answer. You're not going to allow them there. Somewhere you need to draw the line. So there's an interesting case, Calgon Lounge versus National Union of Furniture and Allied Workers Union of South Africa and others case, long name. It sets the call to help there. The deliberate design of the LRA is to designate the task of dealing with workplace disputes to employers' organizations, trade unions, and workplace forums. I don't hear any political parties mentioned there. So that's out of case law straight. We're not going to bargain with them.
And that being said, I think that's a good way to end today's session on that ground. So thank you for your time today.
Pleasure.
That concludes this episode of Stuff Employers Should Know. As I say every week, if you want to get in touch, drop us an email at sesk@labornet.com or hit us up on any of the social media platforms. So from myself and Jas and Kobus, till next episode, please stay safe and cheers.
Stuff Employers Should Know was proudly brought to you by LaborNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.